2022 CR 11792, State of Texas versus Nelda Rios. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Albert Chidas for Ms. Rios.
Are you Nelda Rios?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nelda Rios who was placed on deferred adjudication in 2022 CR 11792 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on April 19, 2023 for a period of 2 years? Is that you?
I do gotta say, I don't remember. I do have a head injury, but
All right. She doesn't remember that she was placed on deferred adjudication. Do you know when she had this head injury? Was it before or after she was placed on probation?
It was before, Judge. And she did remember earlier when we were talking.
In this courtroom hearing, the judge immediately senses something is wrong. The defendant says she doesn't even remember being on probation or agreeing to its conditions. As attorneys outline her homelessness, head injury, and lifelong mental health struggles, the judge is forced to confront a difficult question. What's the right path forward?
It's something that I was talking with the state and with probation about. She does have some deficits. She goes to Center for Healthcare Services for treatment.
All right. So do y'all think she's competent?
She has been. This is the first she says she doesn't remember being on probation. And we had actually talked about trying to help her because she was homeless. There's some issues that came up. She's on SSI for her head injury, but she lost her ID. And when that happened, she got evicted from housing. So we could work something out with Haven for Hope, get them to help her get her ID temporarily.
So are you all looking to withdraw the motion and alternate main conditions?
Judge, we thought that it would be better to come and have the motion heard, but again, that's up to you.
I think it would be best probably to withdraw and alternate main conditions.
Your Honor, we were looking to maybe getting some evaluations done while she was in custody.
So what evaluations are we looking at?
The TAP and mental health evaluation.
My only concern is I understand y'all want to do that in custody, but she's telling me she doesn't remember signing conditions or being on probation. She doesn't have a place to stay?
She was living under a bridge when she was arrested.
All right. So here's my question for you. One or two things can happen. You can remain in custody. While in custody, you will be evaluated. We can reset the motion to revoke, and you can be evaluated for the mental health caseload. Would you like to do that?
I already know that I'm not able of, that I cannot, like you have to tell me all over again if I didn't understand it.
All right, let's do this. Why don't we see whether or not the mental health court will accept her? I know they only do pretrial diversions, but if nobody's going to object to it, I'm willing to do a motion for new trial. And we can start all over because I see I'm not the person who took this plea. So if you would check with mental health court to see if they'll accept her, because that may be the better placement for her, because I think she's going to need one-on-one care. So if you'll check with mental health court and let them know, and you'll have to let.
What began as a routine probation hearing quickly escalates. The woman standing before the judge claims she doesn't remember signing her probation and reveals she's been homeless, battling mental health challenges since childhood.
Let them know that she's currently on deferred adjudication, but I'm willing, if nobody objects, to hear a motion for new trial, grant the motion for new trial, because the key is to get her the mental health treatment. And this is a possession less than a gram case.
Yes, Judge.
Okay. So is everybody on board with that?
Yes, Judge.
Yes, Judge.
All right, so what I'm going to do is I'm going to reset you for 2 weeks. There may not be anything completed in 2 weeks' time because mental health court will have to interview you, but I just don't want to lose track of you in the system. Okay? Do you have any questions?
No,
All right, do you have any family?
I don't. I have that. Sometimes I don't even have money to buy me a meal.
Okay,
I haven't been able to have a bank account with Bank of America, but because I don't have an ID, because when I got arrested, I was in my apartment, and it's a long story. But I had gotten a better criminal trespassing in my apartment, and that's why I got arrested for this case. I'm sorry for it.
oh no,
And then we came to court and went through all this process, but being out, I don't even have money to buy me something to eat or pay for a motel room because of everything I've lost. And I got arrested at the motel. And I know that I have had issues with mental health since I was 10 years old.
okay. All right, so we're going to give you a 2-week reset. And that's just so I won't lose track of you. So now we have a plan. We're going to try to get you in the mental health court and probation. Could you see about the mental health evaluation while she's in custody, just in case that doesn't work out?
Yes, Sean.
All right, is there anything else?
No, Your Honor.
All right, Ms. Ferguson, I need a 2-week reset on Nelda Rios, please. You're welcome. All right, so we're going to put it down for August 29th.
Thank you, Judge.
All right, Deputy, before you take her back, Ms. Ferguson, can you give her a reset form so she'll remember?
Yes, ma'am.
1 CR 0835, State of Texas versus Nicholas Cornelius. Can our parties announce for the record for the state?
Daniel Escobar from the state of Texas. And Jackson Lindsay on behalf of Mr. Cornelius, Judge.
Are you Mr. Cornelius?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cornelius, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge, we're going with the lesser included offense robbery.
Any objection?
No.
Showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions.
A defendant stand before the judge on a serious robbery charge. After spending 15 months in federal custody, he's hoping for a second chance through deferred adjudication. But when the judge asks about his children, the hearing takes an unexpected turn, and the courtroom quickly grows tense.
Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with or at least the state is proceeding on the lesser included offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
It's one of the attachments. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, we're waiving PFI.
All right, anything you wish to say on behalf of your client?
Just so the court is aware, Judge.
All right, so everyone, please whisper in the box. We're on the record. Yes.
Thank you, Judge. Briefly, my client had court in the Winston District Court back on May 31st of 2022. That day, he was arrested by the U.S. Marshals for a federal charge of being a person under indictment in possession of firearms.
Okay.
He spent 15 months in custody awaiting that charge. We worked out a deal in federal court for a plea bargain, accepting his ability to appeal that sentence because that particular statute is being challenged in the upper courts right now. 922 M. 18 USC 922 M. So because he was denied bond, he was in a position where he ultimately pled guilty because he did have the firearms. That explains why we took so long to come back to this court. He's here now, Judge. He's been offered deferred adjudication from the state. He's accepted it pursuant to the court's approval. as part of this federal judgment, after serving 15 months, he was placed on supervised release for 3 years, which I'm asking the court to run that concurrent with this federal case. And that in the event, unlikely event, I believe, he would be picked up on a violation of probation in this court, that any time served in federal court awaiting disposition of that case be credited towards any time given in that case, in the event he's sentenced.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
4, 3, 2, 1, 6 months.
And where are they? Who are they with?
Their mothers.
How many mothers?
3.
All right, that is not Black excellence. The fact that you're here is not Black excellence, unless that's the name of a building, but I'm assuming it's not. So you are not showing Black excellence to your ancestors or to your mother, your grandmother, or anyone. You understand?
Yes, ma'am.
So don't wear Black excellence if you're not showing it.
Yes, ma'am.
All right, are you employed?
Yes, ma'am.
What do you do?
Pack and moving. Apple moving service.
Okay. All right, this is what the court is going to do. Court will sentence you to 3 years deferred adjudication. There's to be no contact with Jose Aguilar. There's to be restitution, if any, to FedEx. Regular reporting. By Zoom or in person. Regular UAs. 200 hours of community service restitution.
A man facing a robbery charge hopes the judge will accept a deal for deferred adjudication. After already spending 15 months in federal custody, he's hoping for a chance to move forward. But when the judge asks about his children, the courtroom goes quiet as she delivers a powerful message about responsibility and what it really means to be a role model.
There's going to be parenting classes. Once he completes parenting classes, that will be deemed to be satisfied. Field visits, 1 time per month for 3 months. And probation, if you all want to check with the federal government and see how their field visits are, you may not have to do any if they're doing them as well. So if you could check with them. There's to be no contact with Aubrey Reed, Aubreyreed, Charlie James Ray Perkins, Amari, Emari, Lafel, Lafel, Freeman, Freeman. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Probation, is there anything else he needs?
Just for 3 months.
Yes. All right, is there anything else you need from the court to have Black excellence in your life?
Oh, ma'am.
Judge, maybe run this concurrent with this federal cause number. I can give you that cause number.
All right, concurrent with what's the number?
SA:22-CR-294.
All right, the court will run it concurrent.
Thank you, Judge.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
Oh, ma'am.
All right, we can go off the record. Here's the thing. From here on out, in this court, whatever you do in your life while you're on probation, you need to ask yourself 2 questions. 1, is what I'm doing something that could potentially result in me being revoked and sentenced to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank
2023 CR 1424, State of Texas versus Luis Angel Gomez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Joanne Eagle for Mr. Gomez.
Are you Mr. Gomez?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilty Revoked Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Luis Angel Gomez who was placed on deferred adjudication in 2023 CR 1424 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on April 6, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Violated condition number 2 on or about the 4th day of May, 2023 in Bexar County, Texas.
A defendant on probation admits to using marijuana, but when the judge starts asking questions, the story quickly gets worse. After skipping a required drug court appointment, he finally confesses he's also been using meth and heroin. Now the judge faces a difficult decision: send him to prison or give him one last chance at treatment.
The defendant, Luis Angel Gomez, did then and there admit to illegal use of a controlled substance, namely marijuana, in violation of condition number 2.
How do you plead to that? True or not true?
True. Your Honor, state waives all the violations.
Any objections?
No objection, Judge.
All right. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor. It's to deny the motion, amend conditions to include SATIF and remain in the Bexar County Jail until Beth's bail.
All right. Is there anything that will preclude him from going to SATF? Any gang affiliation or anything of that nature?
None that I'm aware of, Judge.
Mr. Gomez?
No, ma'am.
All right, Mr. Gomez, I saw that I had referred you to felony drug court and you never appeared. You didn't show up for your screening. And then they tried all numbers. They tried your family and you didn't show up. Why? You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Luis Gomez.
All right, why didn't you show up to your felony drug court appointments? They just tell the truth.
I just wasn't ready.
All right. So what have you been using other than marijuana?
Oh.
Here's the thing, you need to be honest, because I'm trying to make a decision on whether or not I'm going to follow this agreement or whether or not I send you to prison.
Just meth and heroin.
All right. So does everybody feel as though meth, heroin, and marijuana is going to be addressed with SATF? Or does it need to be something more intensive? Because he doesn't, and I mean this in the kindest of way. I remember you, Mr. Gomez, and you're looking.
When the defendant returns to court for violating probation, the judge immediately notices he looks different, thinner, weaker, and clearly struggling. After admitting to using marijuana, meth, and heroin, the court must decide what comes next: prison time or one more chance to intensive treatment that could save his life.
Different, and not in a good way. So I'm trying to figure out, it looks like you've lost even more weight. I'm trying to figure out what would be the best to help you. Now I'm leaning towards inpatient treatment, but it's going to be inpatient treatment and then felony drug court, and hopefully a place will open up for him. So I'm just trying to see if SATF is a good place for him since it's marijuana, heroin, and meth.
Your Honor, our SATF program is geared for alcohol and drug dependence.
Mm-hmm.
We will do and we do have an aftercare program with that.
Okay.
And the aftercare is 90 to 120 days.
Okay.
So they will follow him for an extended amount of time. The other option we have is Safe P. And that is also alcohol and drug dependence.
All right. This is what I'll do. If there's no objection from probation. I'll deny the motion, alter amend conditions to include SATA, follow with aftercare if not accepted into felony drug court.
The aftercare is
Well, no, I already know if he's accepted in a felony drug court is going to take him and have him do the aftercare. But I just want to make sure that felony drug court is a component.
yes, Your Honor. So can we just add felony drug court?
Yes.
Just so that we make sure that he's in the aftercare program until accepted into felony drug court.
Yes. All right, Mr. Gomez, is there anything else you need?
No, ma'am.
All right, you're going to remain in custody until you're transferred to SAT, if you understand. You need to take advantage of that program because the drugs you're using, that's a deadly combination. Using any drugs is a deadly combination, but heroin, meth, and marijuana, that's a major problem. Do not be the person on the news where I get a report and they say, oh, we're terminating his probation because I get a deceased starter. You understand?
Yes, ma'am.
All right. If you need anything, we're here to help you. And this court communication is key. Make sure you stay in touch with probation. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.